Hi friends, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. Here's what we're discussing today. Every now and again I am out there looking on YouTube and finding different things to think about and talk about, and today I happen to come across a channel by the name of Charles Askram. I assume he is an attorney. I assume, or at the very least, I assume he's in Albuquerque because most of the stuff on his channel is about Albuquerque. If you're interested, I have the channel linked down below. I took a look at this because and I want to put it out here today because it illustrates a point that I try to make, particularly with young attorneys and particularly with overworked professionals, about what is and what is not an affidavit, or if you're in federal court, a declaration, and why it is important to pay attention to the words that are used, and it's also important to pay attention to a certain requirement. Now, in order for me to testify about something, I have to have personal knowledge. So what I got in the mail today, I have personal knowledge of that. And the length of my driveway, I have personal knowledge of that. But there are many things that I do not have personal knowledge of. And although I may have knowledge of them, in other words, knowledge acquired from another source, someone may have told me, or I may have read it in a newspaper or something like that, I don't have personal knowledge of the facts that are at issue. So when someone comes to you and asks you to sign an affidavit or a declaration that they have prepared for you, I think it's really important to understand exactly what you're doing. What you're doing is you are walking into a court of law, effectively, raising your right hand, swearing to tell the truth, the whole truth, and nothing but the truth. You are stating facts that you believe to be true and of which you have personal knowledge, and then you're walking away without any cross-examination. Nobody is going to ask you questions about that when you file the affidavit. But that doesn't mean that there aren't going to be questions about that testimony later on. So when someone walks in and slaps an affidavit down in front of you and says you need to sign this, it's not the same thing as approving invoices. It's not the same thing as writing checks. It isn't a normal business function that you're doing. You are testifying in a court of law, and there are rules that apply to that. One of the things that I always do when I prepare an affidavit is first paragraph is, my name is John Doe and I am over the age of 18 years. Now, you don't have to put their age in there if you don't want to. Women particularly seem to be rather put off by having to put down that they're over 30 years old or however old they are. And as a result, I simply, in order to make things easy for people, I will put I am an individual over 18 years of age. That tells me that you are legally accountable. You are not a minor, you are an adult, and you understand that you are personally accountable for what will come after in this affidavit or declaration. The second thing I put on there is I have personal knowledge of all of the facts expressed in this declaration as set forth below. What does that mean? It means I saw it, I heard it, I witnessed it, I was there, all of the things that you would normally be expected to say if you were in court. The reason you have to have personal knowledge is because if you put hearsay into an affidavit, it doesn't make it admissible. And in fact, in many cases, it can get the whole affidavit thrown out. But in most cases, simply a hearsay statement, one hearsay statement in a long affidavit, will simply get that statement stricken. There'll be a big black thing over it when it gets admitted into the record. And here's a good example of how this personal knowledge requirement comes up in court cases. In this case, one of the individuals challenged the summary judgment ruling because a counsel's affidavit was used. In other words, a lawyer testifying to what he saw, witnessed, heard, that sort of thing. Lemon argues the motion court erred by considering counsel's affidavit because it did not comply with Rule 7404. The court denied Lemon's motion to strike, but ordered that all or part of 19 statements in the affidavit be stricken. The stricken statements pertained primarily to counsel's views on the ultimate legal issues, whether probable cause existed to file the 2015 lawsuit, and whether the Hopkinses acted with malice in filing that lawsuit. So, obviously, as you can tell, he could not have had knowledge of whether the Hopkinsons acted with malice in filing that lawsuit. He can't have had personal knowledge of that. Rule 7404 requires that affidavits be made on personal knowledge, setting forth such facts as would be admissible in evidence and show affirmatively that the affiant is competent to testify to the matters stated therein. If an affidavit does not show a basis for personal knowledge, it is considered hearsay and is invalid. Counsel's affidavit is modified by the court, complied. The affidavit contained a declaration of personal knowledge. In other words, he stated that he was a person over the age of 18 and competent to testify to the matters contained herein, and all statements made herein are from his personal knowledge and are believed to be true and accurate. Counsel's affidavit complied. It stated the affiant represented the Hopkinses in a 2015 lawsuit. That showed his basis for personal knowledge because the basis can be gleaned from the role of the affiant as stated in the affidavit. That's case law. And the affiant's role as his counsel was sufficient to establish his personal knowledge. So things that he didn't have personal knowledge of, for example, whether they acted with malice or not, those things were stricken. So you can have an affidavit that's partially good and partially bad. The long and short of it is that you have to know exactly what happened. You can't testify to what somebody else might be able to testify to. You can only testify to what you are able to testify to. So if you saw it with your own eyes, if you heard the sonic boom, if you saw, the guy fire the weapon and you heard the sound of the weapon being fired, those are all elements of personal knowledge. But why someone fired the weapon, unless, of course, they stated it, if you're just assuming that they fired it because they were angry or something else, that is not personal knowledge, so you have to be really careful about what's expressed in an affidavit. And then the next thing that I put into an affidavit after this personal knowledge piece is I have never been convicted of a felony or a misdemeanor related to making false statements. Period. And you need to do that in most cases to set forth the fact that this is a person who has some credibility. And then, of course, what any good attorney does when they draft an affidavit is they set forth the conditions under which this person was able to observe what happened. I was walking on Main Street on July 7th, and I stopped at the stoplight waiting to go across. And then in the next paragraph, while waiting for the traffic light to give me the walk signal, I saw the blue car hit the red car in the middle of the street. I looked up and realized that the blue car had run the stop sign or the stoplight or whatever it was. Those are the kinds of things that you put in. The fact that you had the ability to see it or hear it or whatever, then you saw what happened and you're just stating what you saw. And then at the end of it, the attorney or whomever is drafting it, and sometimes it's a paralegal who drafts them, will put further affiant saith not, meaning you're not going to say anything more on this subject. That's the extent of what you can testify to. You then have to sign it in front of a notary public, who is somebody who is authorized to administer oaths, and a good notary public will swear you in. Do you swear that the affidavit that you're executing is from your personal knowledge and that you have told the truth, the whole truth, and nothing but the truth? And then they will swear, after swearing you in, you will sign it, they will notarize it, and it becomes an affidavit. And of course, if you're executing a declaration in federal court, you sign it under penalties of perjury, which has the effect of being sworn and stating it under oath, because you're testifying under penalty of perjury. All of these things are necessary to make an affidavit. Where you get into trouble is in this situation.
This is a June 29, 2023 declaration of Mayor Tim Keller. Do you remember signing this document?
Yeah, this is when I referenced that, I signed paperwork associated with legal cases. This is what I was referring to, these kinds of things.
Do you have an idea as to why you signed this document?
Actually, I don't know. I did read it and certainly attest to it and agree with it and sign it. But I don't know what the case was about or anything.
You have any idea what the issues are?
I don't.
Do you know who Jeremy Deere is?
I don't, other than when I saw this, I remember seeing this document. But before seeing this document, it doesn't ring a bell.
On paragraph 9, you state, it's on page 2, you state, I did not direct anyone to file a counterclaim against Jeremy Deere and Deere versus City of Albuquerque, and then a state district court case. And then in paragraph 10, you state, I did not approve of a request to file a counterclaim against Jeremy Deere in the same court case. Do you have any idea what's being referenced in those two paragraphs?
I don't.
So essentially, what the mayor in this case is doing is he is testifying, but he's not testifying from personal knowledge. He looks through this and he says, yeah, I told him not to file a counterclaim. Do you even know who this guy is? No. Did you tell him not to file a counterclaim? I don't know. He put it in the affidavit, but he didn't actually do it. He believed that he was just signing legal papers. Well, if you are signing legal papers and it says affidavit at the top, you are testifying under oath. And if you testify under oath and you testify falsely, you can be convicted of making a false writing. You can be convicted of giving false testimony. It's effectively perjury. And you can go to jail. Now, is it always prosecuted? No, it's prosecuted very rarely. But the thing is, you shouldn't do it. And then later on, if it becomes widely known that you do this, lawyers are going to gather up all of those affidavits that you later testified you didn't have any personal knowledge on, and they are going to use that to impeach you on a lot of other things. Now, over here, you said you had personal knowledge, but you didn't. So now when you're saying that you didn't fire this person, why should we believe you? And of course, people always respond to that by saying, well, that was then, this is now. The bottom line is it impacts your credibility. So if you are drafting an affidavit, you need to make sure that you are drafting it accurately. And in fact, I worked with a private investigator once who always put at least one error into a statement whenever she would draft a statement that she asked somebody to sign. And as they were going through the statement, when they got to that, he said, well, I don't think I said it was a blue car. The private detective would go, oh, you're right. You said it was a red car. Why don't you line through blue car and just write red there? And they would do that. And now, would you just initial that? Yeah, okay, now we're good. So now you have proof that they have actually looked at the statement. And sometimes when you're drafting an affidavit and you have draft across the diagonally across the face of the page that they're looking at, it's a good time to put something in there that they ought to catch. And then if they don't catch it, you have to bring it to their attention and say, hey, are you sure that that's right? And, I don't have that in my notes and I don't really know where that came from. One of the things that happens is people get so used to, just as this guy did, signing legal papers that they don't pay any attention to what they're signing. They look at it and they go, oh, okay, here, let me scribble my signature on there and we'll call it good. It isn't good. if it isn't right, it isn't good. If it isn't true, it isn't good. And so you have to be sure that what you're testifying to is truthful and accurate. And here's the best reason for that. The reason is if you are testifying and you get something wrong, you are going to be impeached on it on the stand. Somebody is going to bring that affidavit up to you and say, do you recall signing this affidavit? Yes, I recall signing that affidavit. And up here it says that you're over 18, right? Yeah, I haven't been convicted of a felony, right? And that you're making this statement from personal knowledge, right? Yes. Now, explain to me how you have personal knowledge of this fact. Well, I'm not sure I can explain how I have personal knowledge of that fact. So what you're saying is that in order to get something, you filed this affidavit, but it's not truthful. Well, it may not be accurate. Well, if it's not accurate, sir, is it not untruthful? There are a lot of ways that words get twisted in a court of law, and so the last thing you want to do is to give the other guy some kind of ammunition to use against you. Now, sometimes as a lawyer, I find it very, very frustrating when I prepare a declaration or a document for someone and they nitpick. But I remind myself after they have nitpicked and pointed out that, I've misspelled the word, or that I didn't get something right, or that I misinterpreted their intent, something to that effect. I realize that what they've really done is they've helped me out, because if they ever get cross-examined, they don't have to explain why they didn't read it very carefully. And that's a good thing. So I offer that as a cautionary tale. And if you are ever asked to file a declaration or an affidavit, make sure that it is accurate, make sure that it is truthful, make sure that if you wouldn't say it that way, that you make the attorney or whoever's drafting it say it the way you would say it. In a particular case, there is a situation where somebody was asked to resign, and they did resign, and the attorney characterized it as being fired because that was the words that the attorney had used. And the person in answering the question, in that case in a deposition, said, yeah, that's right. And then later on, when he denied that he had fired that person, the distinction being that he had asked them to resign, the effect was to, essentially undercut his credibility to some extent, because he was using words that he had agreed with. He was using different words than he had agreed with earlier. And you don't want to ever give the opportunity to somebody else to impeach you on the stand with your own testimony or your own statements that you made earlier. Well, that's what I have for you today. Go on over to Charles Askren's channel and check that out. I think he's got some interesting stuff, particularly if you're interested at all in what's going on in Albuquerque, New Mexico. It looks to me like they had some issues there with their police chief, and this particular person is interested in that and has this video up on YouTube under his channel name. So thank you so much for watching. If you have any questions or comments about this, you can leave them in the comments down below or email me at the address above. If you have the opportunity today, do something nice for someone, and then catch me down here at the beach again next time. If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.